This is in regard to the charges as per the amended charge sheet, which was amended on the 31st of December. In accordance with the charges therein, the first, second, and third accused persons were convicted on their own plea of guilty in counts number 1 and number 2 for the offence of being in possession of a psychotropic substance contrary to section 3, subsection 1, as read with section 3, subsection 2 of the Narcotic Drugs and Psychotropic Substances Act number 4 of 1994. In accordance with the particulars in count number 1, the three were in possession of 118.30 grams of cannabis with a market value of 3,549 shillings, whereas in count number 2, we were charged for being in possession of 28 tablets of flunitrazepam with a market value of 1,400 shillings. The fourth and fifth accused persons are convicted in their own plea of guilty in the third count for the offence of being in possession of psychotropic substance contrary to section 3, subsection 1 and 2 of the Narcotic Drugs and Psychotropic Substances Act number 4 of 1994, and the particulars therein that the two, that is accused number 4 and number 5, were in possession of 13.33 grams of cannabis with a market value of 396 shillings and 60 cents. In the fourth count, all 5 accused persons pleaded guilty and were convicted for the offence of being unlawfully present in Kenya, contrary to section 53, subsection 1J, as read with section 53, subsection 2 of the Kenya Citizenship and Immigration Act. The sentences for the offences as charged in section 3, subsection 1 of the Narcotic Drugs and Psychotropic Substances Act, the sentence is dependent on the substance in question. It stipulates subsection 3, subsection 1 states as follows, and I will read it. Subject to subsection 3, any person who has in his possession any narcotic drug or psychotropic substance shall be guilty of an offence. Subsection 2 states, a person guilty of an offence under subsection 1 shall be liable, A, in respect of cannabis, where the person satisfies the court that the cannabis was intended solely for his own consumption. The imprisonment term is for a term of not more than 5 years or a fine of not more than 100,000 shillings. Subsection 2B, in respect of a narcotic drug or psychotropic substance other than cannabis, where the person is in possession of less than 1 gram, to a fine of not less than 5 million shillings or to imprisonment to a term of not less than 5 years, or both such a fine or imprisonment. It is clear, therefore, that from the provisions that I've just set out, that where the substance in question is cannabis, and the said cannabis is intended solely for personal consumption, the prescribed sentence is a term of imprisonment of not more than 5 years. And I underline that provision, not more than 5 years, or to a fine of not more than 500,000 shillings, not more than 500,000 shillings. Whereas, when the offence relates to a narcotic drug or psychotropic substance other than cannabis, underline that, other than cannabis, including where the quantity is less than 1 gram, the law stipulates a mandatory penalty of a fine of not less than, underline that portion, not less than 5 million shillings, or to imprisonment to a term of not less than 5 years, or both such a fine and imprisonment. Section 53, subsection 1J and 2, and section 53, subsection 2 of the Kenya Citizenship and Immigration Act stipulate the sentence for being unlawfully present in Kenya, and it states, a person who unlawfully enters or is unlawfully present in Kenya in contravention of this act commits an offence. And subsection 2, any person convicted of an offence under this section shall be liable upon conviction to a fine not exceeding 500,000 shillings or to imprisonment for a term not exceeding 3 years or both. In the process of sentencing an offender, the court ought to bear in mind both the aggravating and mitigating circumstances in arriving at an appropriate sentence. And in doing so, the court must consider the circumstances of a crime, the personal circumstances of the accused person, the impact on victims, and the effect of the crime on the public at large, and also to bear in mind the need to prevent and deter future crimes of a similar kind. A vital factor in this regard is the criminal history of an accused person, and where an accused person is a first-time offender, the court should exercise leniency and to bear in mind that maximum sentences are reserved for repeat offenders. While this court is alive to the fact that the convicts in the present case are first-time offenders, this fact alone does not take away from the seriousness of their offense, and it must be taken together with all other relevant factors. In their mitigation, the convicts expressed remorse and urged the court to consider that they are young persons and they sought the court's leniency. Also, the quantity of the cannabis in count number 1 and count number 3 is not very high, and which suggests that the same was for personal use as was contended or alleged by the accused persons in their mitigation. Having considered all the circumstances surrounding the offense, this court therefore proceeds to sentence the convicts as follows. In count number 1, the first, second, and the third accused person are hereby sentenced to a fine of Kenya shillings 30,000 each. In default, they will each serve an imprisonment term of 1 year. In count number 2, in accordance with the mandatory sentence stipulated under Section 3, subsection 2b of the Narcotic Drugs and Psychotropic Substances Act, this court therefore proceeds to sentence the first, second, and third accused person to a fine of 5 million shillings each, in default an imprisonment term of 5 years each. In count number 3, the fourth and fifth accused persons are hereby sentenced to a fine of 15,000 shillings each, in default to serve an imprisonment term of 6 months each. In count number 4, the first, second, third, fourth, and fifth accused persons are hereby sentenced to a fine of 10,000 shillings each, in default to serve an imprisonment term of 1 month each. In accordance with Section 333, subsection 2 of the Criminal Procedure Code, any duration of time that has been spent in custody by the accused persons in the course of the proceedings herein shall be taken into account in computing the sentences as read out above. The convicts are hereby informed of their right of appeal within 14 days of today's date. That is the sentence of the court.
Much obliged.
Much obliged.
Your Honor, will be seeking an order for repatriation once they have served their sentence or paid the fine.
The accused persons here, now convicts, will be repatriated back to their country upon payment of the fines or upon completion of their sentence of imprisonment. the investigating officer to collaborate with the immigration department in undertaking the repatriation exercise. Mr. Mwavu, I hope you understand that we still are grappling with the issue of the mandatory minimum sentences. One of the offences for which your client were convicted on their own plea of guilty carries a mandatory minimum sentence. It's an ongoing debate. I will encourage you to pursue that. Thank you. You may all be seated. You will obtain copies of the documents that you need.